Hi guys, it's Kathy. I hope you're doing well. Just another friendly reminder not to watch Judge Fleischer TV. They are not affiliated with Judge Fleischer and their slime balls. So, today is a little heavier. We are going to go through a sentencing. The murder trial already happened. He was already found guilty and now he's being sentenced. And you're going to see a lot of bailiffs because during the trial, the gallery was fighting with each other physically. Like the guards had to keep pulling people off of each other. We have the victim's family there, and then we have, it's a robbery going wrong. I'm not 100% sure the person here today was actually the one that pulled the trigger, but he was involved in planning this robbery that took the life of someone. So we got the families there and the judges trying to keep them apart. And then we have, the defendant. So let's get going. This is another one of the Indiana judges that you can only see here. You won't be able to see them anywhere else. I think this is Judge Francisco. Yeah, this is Judge Francisco. Here we go. Follow what was going on. We're going to see all the bailiffs right now for the family members. There he is.
All right, fellas. People are still coming. There's just a lot of alcohol in there. Oh, sorry. Where you want? No way. So you walk around town getting all those compliments that you're wearing my hat that are meant for me. What is? Hey, I'll let you know. I'll do you have a text message every time. It feels like big masters for the day where they had. I wouldn't wish that on anybody.
That's what I'm saying.
I'll leave my pipe and say I'm not. I'd have to go along with that real quick. A couple of years ago, there was a few public defenders that were going to dress up like masters. Well, people can hold off.
I'm trying to hear what they're saying about those public defenders. Are we hearing gossip?
Listen.
It looks like they just let the victim's family in, I think. They let them in separately, the two families. They're not allowed to be near each other. And when they're leaving, the judge is like, okay, you guys get out of here and make haste. I want you out of here right now. Before he could leave the other ones out. All right, Francisco, where are you?
After a series of filings and arguments, the court declined any judgment of conviction and rescheduled the matter for trial. The parties reached a plea agreement on November 13. Devon pled guilty to the added count of robbery as a level 2 felony with a firearm enhancement. The plea agreement calls for a floor of 20 years and a cap of 40 years on the executed sentence. The remaining counts to be dismissed. We originally scheduled this for sentencing on December 17. The state filed its sentencing memorandum and appeared in the memorandum. The state was conceding that Mr. Vaughn was eligible for consideration as a youthful offender. The court wasn't so sure on that, but did allow, or we said it to today, to allow additional time on that issue. Mr. Masters, you also filed a motion for youthful sentencing alternatives as well. The court did contact the juvenile division of the Department of Correction, and they advised that they believed that Mr. Vaughn needed to be 18 or less than 18 at the time of sentencing. The court forwarded that email to the parties. So we'll address that in a minute. But Mr. Masters, have you reviewed the pre-sentence investigation report, sir?
Yes, I have.
Are there any corrections?
The credit time reflected in the pre-sentence report was calculated through the original sentencing date of the 17th of December. I would add to that at least 30 days counting through yesterday.
At 31.
As you say that, I think the court is right because I think I did not count the 17th of December when I did my calculation. So my one correction there would be to add 31 days, making an actual jail term of well, exactly 1 year, 365 days.
And Ms. Feldowski, do you agree with that?
Yes, sir.
All right. And so, Mr. Masters, any additional corrections to the PSI?
No, thank you.
Ms. Feldowski, how about you?
No corrections to the PSI, in the state's sentencing memorandum, to those juvenile adjudications, the state listed out additional information, some through the court records. I just would ask the court to keep that in mind.
The court will, and I will note also during the trial of this, there came a moment in the trial when there was the issue of whether or not prior acts would or would not be admissible. And in the course of that, Ms. Feldowski furnished the court with reports that somewhat documented a lot of the underlying matters in juvenile, as well as some that weren't actually charged.
There was an incident that the intention was that there would be evidence presented that he was injured as a result of a gunshot. I believe during the trial, those reports from the Southland Police Department would reflect that it was like a victim of a drive-by or something like that. It was a group of juveniles at a house party that were essentially passing a firearm around or playing with guns. So that's not to say that he was a victim of a situation or about an offense where it was as egregious as that, but merely kind of a consequence or a reaction of the situation in place itself. So.
Okay, understood. Now, Mr. Masters had previously submitted, I want to say roughly 23 or so letters in support of Mr. Vaughn, which the court read and revisited in preparation for today. Mr. Masters, you also filed a written statement by your client. And Ms. Feldowski, did you see that?
I did.
All right, so I believe that recites all of the matters up to date. Would you agree, Ms. Feldowski?
Yes, Judge.
Ms. Masters?
Senator, I received one additional letter this morning that I filed as promptly as I could. I'm not sure if it's been received by the clerks yet. It's from a Julie Ann Clark, who is a coach and instructor. I have a hard copy if the court would like to examine it, but I can paraphrase it in saying it repeats much of what the other writers would say about Mr. Vaughn's character.
I have it. It has gone through. Ms. Feldowski, have you seen it?
I haven't. I briefly looked at it this morning. I was tied up in the sentencing this morning to Stanford's that was took up my time. But I believe Mr. Masters and summarizes it. I would note that I have 3 letters presented to me by immediate family members of Mr. Gallegos that they wish for me to read to the court today. They're not particularly long. The family members, 2 of the 3 are present, but it's just difficult for them to address the court, and we will have one individual speaking on behalf of Mr. Gallegos.
All right, absolutely. All right, so Mr. Masters, just give me a quick second. Let me read this one.
So they said both. They said there was a trial, then they said he took a plea. So I'm a little confused about what happened before. I do know it was a robbery. He he and a group of friends planned this whole robbery, and I think he did a lot of the planning.
I read the letter from this.
It said youthful offender. He is being tried as an adult right now, and I believe right now he is an adult. I'm not 100% sure he was an adult at the time of the crime, but he is an adult right now. And the judge has words to say about, he's too young to understand.
And Clark, who was identified as a coach/instructor. Okay, we'll now turn to evidence. So, Mr. Masters, if you have anyone that you want to elicit evidence from, we'll have you call your witnesses first. And then Ms. Golobiewski, I'll let you call any witnesses you want or read any letters you want at that moment. Of course, if your client wishes to say something, that happens. So, Mr. Masters, do you have any witnesses that you want to give testimony against?
I do, Your Honor, and I would first, with the court's permission, acknowledge that present in the courtroom are both of Mr. Vaughn's parents, a number of other blood relatives, friends, and well-wishers. In the interest of presenting a concise presentation, I have asked Matthew Lewis Rice, who is present here, to speak as perhaps a spokesman for the family.
Certainly. Sir, if you want to come forward. Ultimately, sir, you're going to make your way to that seat. On your way, I'm going to have you pause right about there and have you raise your right hand, sir. You swear or affirm under the pains and penalties of perjury that the testimony you give is the truth, the whole truth, and nothing but the whole truth.
I do.
That seat right there, sir. Now, sir, Mr. Vaughn's attorney, Mr. National, will ask some questions first, and then Ms. Golobiewski will get an opportunity to ask some questions as well. You can answer questions, don't say or because we are recording these proceedings. Go ahead, Mr.
Thank you, Your Honor. Matt, for the benefit of the recorder taking this down, could you state and spell your name, please?
My name is Matthew Lewis Rice, MATTHEWLEWISRICE.
Matt, we're not strangers to each other.
No, sir.
When I went into private practice, you were actually one of my first clients when I represented your mechanic business.
Yes, sir.
And I learned through defending Luttrell that you have a connection with this young man.
Yes, for about the last 14 years of his life.
How did you come to know Luttrell?
Through the mechanic shop, I was actually working on his family's cars.
And about what age would you say Luttrell was when you first met him?
He might have been 4 going on 5 years old.
Fair to say that you struck up a friendship with his family?
Yes, sir.
And from ages 4 to 5 to now just past the age of 18, have you spent a lot of time around Luttrell?
Quite a bit, yes.
I guess the first thing, what would you like to know about the Luttrell you came, or what would you like the court to know about the Luttrell you came to know?
The young man that I watched grow up has faced adversity. He's been helpful in every situation that I've seen him. He's been known by his mother and most of his family as a protector of his own house. As I watched him grow, he played sports. Always had like a team-like mentality, never left anybody else behind. Anybody in the neighborhood could call him whenever they had problems, no matter what it was, and he would be there for any of his peers. I've seen him sacrifice his own time and take accountability on things that he was a lesser man, a young man growing into a good man, would have avoided entirely. And I've seen him take that mantle with peace and accept things that other people would shy from.
Matt, there's something in your own life you've been very open about, which is that you spent time in the prison system. Is that right?
Yes, sir.
What did you personally learn by serving a sentence in the Department of Correction?
that there's a choice that we have and consequences to our own action. And no matter what that is, we have a daily choice to make something better and positive out of it.
What type of programs or services did you avail yourself of when you were serving a sentence?
I actually acquired a ministry degree and a culinary arts degree when I was in there. We actually started a couple different programs through the DOC that was approved.
The cooking
You
pastor.
anticipated I asked perhaps my next question.
He makes his
The
own
things
holy
that you
bread.
learned that way, how are you applying them now?
On the outside of the fence,
Yes.
for an example, we do a Bible study that is carried through. There's men that reach out, women that reach out to Michelle for counseling, mentorship, when they have problems, when they struggle with things. And we are moving forward, pressing into like a home group in a church and reaching out into other areas and avenues to reach out into like, say, homeless centers and help people with like winter jackets, blankets, clothes. That's family that he has that supports him.
Matt, would it offend your sense of humility if I suggested that you are an example of somebody who can rehabilitate himself in prison and come out as a force for good?
I believe that would be very accurate.
What, if anything, would you like Luttrell to do with the next years of his life, however long they may be, or however, or wherever he may be?
Keep faith and hope and know that whatever it is, it's not the end. And that there's always something better tomorrow. I want to see him finish up his education that he's been working on diligently for the last year and make something out of himself for himself, his mother, all his siblings, his father, and the rest of his family that's here every single day with him and supports him.
And if he so choose, would there be a place at the right time within your works or your ministry for Luttrell?
Absolutely.
Matt, sincerely thank you. I'm going to pass you now to the state for recording. If anyone else has questions for you.
Thank you.
Ms. Valdez, do you have questions?
I don't have any questions from the floor.
Why would she have a
So I
question?
thank you very much, sir. You can return to your seat.
Thank you, sir.
Mr. Masters, do you have any additional witnesses that you'd like to call, sir?
No, thank you.
That's it? One character
Ms.
witness?
Valdez,
Him?
You can go ahead and proceed with your presentation of evidence.
Your Honor, if I could start with reading some of the letters of the family members to Brother Gallegos, many of them that are present here today, including his sister, his grandfather, and his aunt.
His sisters,
From his father.
his brothers, his aunt. She got a letter from his father, from the victim.
Gallegos and was unable to attend today, and the letter states, "My name is Frank and I'm Dakota's father, and I want to say thank you for giving me a chance to say something today, to be the voice for my son. I would like to say thank you to the prosecutor for not giving up on Dakota, not giving up on my family, for communicating and keeping my family informed and updating us on information that came up on this case. Thank you. I want the other victims on this case to know that they are in my prayers and to be strong. To thank you for speaking on behalf of Dakota. I'm sorry for all that you had to go through this tragic situation. Dakota was my only son, and he was a good kid and a great friend for what his friends and classmates have had to say about him. I always taught my son to always protect the ones you're with. I always taught my son to always
She's reading the father of the victim's letter. Come on, lady. Do better.
protect the ones you're with. For what his friends and classmates had to say about him. Protect the ones you're always protect the loved ones, never really others. He was a protector. Kids felt a sense of security when he was around. That's my son Dakota. He had a funny personality. I am brokenhearted without him home. To talk to him every day, to tell him all the time I'm sorry for not being there when he needed his father. So for the rest of the days, I will talk to troubled young youth, the pain. I will talk to troubled youth, the pain those caused to them and their families. Before I end this, to the boys that are in court today learning their fates, I feel we should get the maximum of their guidelines after life or life. So please, to the judge, just give them something to stand for. Thank you. God bless you.
She did really terrible at it.
We've also been given a letter from Alicia Daisy, who is Dakota's aunt.
I'm sorry, can you say the name again?
Alicia Daisy,
I mean, what the last name?
Daisy.
Oh, okay. And this is Dakota's aunt?
Yes.
Can you pull the mic a little closer?
We're going to hear some testimony from the family that is, Josh, it's more like Matt. You know how we did that trial and the family members got up and they all said sad stories and then Matt got up and Matt said what he thought. We're going to hear some of that today.
Good.
Dakota is my nephew. I have raised him since he was 2 years old. He was a good kid who didn't deserve to die, all because two boys wanted to be dirty and planned to rob people. I know what Dakota did was wrong, but he was not trying to rob anyone. Dakota has two sisters that can't ever see or talk to him anymore, never able to hug him. But one day we'll be out and free, and while our family will always be grieving for our loss. I pray Judge Francisco sentence you to the max that you deserve for taking a life, a brother, son, nephew, grandson, cousin.
She asked for the max, the maximum.
I gave you plenty of time for you to realize you can't just walk around planning to rob people and shoot them. I pray you get what you deserve, because you will be able to call home still, and family will still get to visit you. Still, one day you will be free after your sentence. That's not fair or enough for our lawsuits. And then I have one more letter from Dakota's younger sister, Isabel Gallegos.
Isabella?
It says Isabel, Isabelle.
And this is his sister?
Yes.
Go ahead.
I am Dakota's sister, Isabel. I have no idea how to start a letter like this, so I will tell you about him. He was forgiving, stubborn, and funny. He had an amazing memory, and he was good at making people laugh. He would make friends easy and always would spend time with our cousins and try to help the others in our family. He liked to be outside, fishing, hunting, playing sports. He never got to see the age of 18, and we will never see him or hug him, and we'll only be able to hear his voice over the phone. We had fought like siblings do, but we always made out the same day. In hindsight, I cannot remember what any of them were about. It all seems so childish thinking about it now. I would do anything to have that time back. When my brother was in a position where he was trying to make sure his friends and siblings were going to be safe, he acted in his last moments of his life. He worried about others. They made the choice to go back in there with loaded guns. I don't know what was planned. I don't know what was planned or if it was a sudden decision choice, but I know, or if it was a sudden choice, but I know that the decision he made in a split second ended my younger brother's life and ruined our family. We will grieve to put up the rest of our lives. When you took him from us, you left an emptiness that will never be filled and a pain that I can never express. Those are all the letters I have, and I would note that the statement forwarded to Mr. Masters and Ms. Hoffman, a letter from Monica as well. I have a copy of it here.
This is another letter
Yes, and I can read it if the court would like.
from Monica.
Yes, it's Monica. I think it's Howe, Hogue. Gue.
Yeah, why don't you go ahead and read it? Right, go ahead and read that. Who is she?
I believe she is Dakota's stepmother. Yes. Stepmother.
I thought you said stepmother.
Yes.
Go ahead and start with this.
There are no words to express the heartbreak over Dakota's death. Our family has been completely shattered by our irreplaceable loss. Seeing the photos of our loved one lifeless is an image that will forever haunt us. Hearing what happened is a story that will forever be echoed throughout the years to come for our family. The action that one's choice took away our loved one at the age of 17. I ask the court for the full maximum sentence, and the family has conserved the same.
She asked for the maximum sentence.
A great deal. Thank you, Monica. For Mr. Bagger's Dakota's grandfather's.
So you're gonna end up
Go
right
right
there.
there. Yep.
I'm gonna have you stop right there, raise your right hand. You swear affirm under the pains and promise to perjure the testimony.
I don't know if this is Grandpa, but if it's Grandpa, we should listen to this one.
And give the truth and the truth and the truth.
Yes, sir.
You have a seat right there. So Ms. Scott, the FC's gonna ask you questions, and then Mr. Masters is gonna ask you questions as well. You need to answer nice and loud and clear in the microphone because we are recording proceedings. And try to avoid using alcohol. Okay, so,
That's good.
very good. Go ahead, Ms. Gordon.
Sir, could you state and spell your name for us?
Yes, excuse me. Francisco Gallegos,
And how do you spell your first name?
Francisco
And your last name, sir?
Gallegos, Gallegos.
And what is your relation to Dakota?
Grandfather.
Okay. What do you want to tell the court about Dakota as a person?
Well, he was bundle of joy and he had a good heart. He was a people person. A womanizer too. But he wasn't an angel either. He used to go out and party and you know that life, that excitement. But it happened. Whatever happened, and I'm here today to I forgive you. It's hard. I do. And I hope my granddaughters find in their heart to forgive you also. I mean, and I'm not here to hate or wish you harm. Whatever happens, whatever the judge sentences you to, it's gonna be a just sentence. It's not gonna be no less. And with that, Dakota had a lot of family, and he did his own way God. And like I said, I'm not gonna be here to dog you, to down you. You hurt your family also. You hurt your family too. That you never ever gonna realize how much what you have done. And I am not here to, like I said, I'm not here to push you to the ringer or nothing, because you did that to yourself. Whatever you did was on you. And we have a small family, but he had a bunch of cousins and second, third cousins. And I do believe one day, when you get to the age of my age, you're gonna know where I came from. Because I know the court system, I know the inside of prison, jail, prosecutors, defense lawyer, I know all about that. I contribute my sobriety to Dakota in 7 years. I promised him I would not drink or do drugs, and I haven't, because of him, because he was he come visit me in the center, probation center. And
Do you think he really did forgive him? Do you think so? I mean, he sounded sincere.
he asked me, he was like, Grandpa, where are you gonna quit drinking? And that, he was 11 or 12 years old then. That opened my eyes and that made me want a future with him. I never had that because of what happened. And his family, I hope you guys forgive me for just forgive me for because sometimes I feel like I did my job as a grandfather by not being there. So I know it's not my fault that what happened, but I feel some responsibility for that. So whatever the judge hands you, I'm gonna go with it, whatever the outcome. I mean,
He thinks it's his
I
fault.
would accept it, I would have to accept it.
He's the victim's grandfather.
And I want to thank the prosecutor and her colleague for being there for us, for helping us. And I want to thank you for not going to trial, so the family don't have to go through all that again. So with that, that's all I have to say for now. I'm done, and like I said, I forgive you. I mean, I wish any harm to nobody, especially that you had done. So whatever the judge hands you, it's on you. With that, I close.
I have no further questions.
Mr. Masters, do you have any questions, sir?
Sir, I don't have questions for you, but if you'll allow me a comment. The words that you've said there are not the words that I usually hear from people in your position. And I think you must be a very special human being to say the things that you've said.
Thank you.
And so, on behalf of Latrell and his family, the grace you're extending to him is so uncommon, but is so gratefully received. God bless you, sir. I will pray for you.
Thank you.
Thank you, Mr. Mayor. Mr. Mayor, turn to your seat, sir.
You can see.
Ms. Gaudioski, our next witness.
I have no other witnesses or others.
No other witnesses?
No.
Okay.
He did not ask for the
All right,
max.
We are now going to
Everyone
turn
else did.
over to the arguments of counsel. And Mr. Masters will make arguments first. And I would imagine in your arguments, Mr. Masters, you will also explain to me your relief why your client is eligible for sentencing for
Yes, Your Honor.
Go ahead, sir.
Thank you.
I don't know. I might be like that. I'd be like, yeah, Judge, I forgive him. Let him out of jail. Release him. Let him out. Release him. I forgive him.
I suppose with respect to that issue first, Mr. Vaughn's eligibility for youthful offender treatment. I think it is such a new and somewhat novel area of the law that when I researched the case citations.
New and novel. Okay.
Interpreting the youthful offender statute, it seemed to me that the oldest of those cases dated to 2021. And so I think it's a statute that is probably still a matter of some debate and interpretation in the appellate courts and the Supreme Court. What I find that I can't sort of facially ignore is the precise language of the statute, which is that if a defendant is convicted or pleads guilty before the age of 18, the statute concludes that the offender is eligible for youthful offender treatment. And so as I read the plain language of the statute, I believe Latrell at least nominally meets that single criteria. Now, I can't control the decisions of the Department of Correction, I think, any more than the court or the state could. But I suppose it's just to say that I divine the legislative intent from the language that the legislature used. And it had the intention of the legislature then that your case must be completely concluded before you turn 18, all the way through sentencing, that perhaps the legislature would have said that as opposed to saying you still qualify if you plead guilty at under the age of 18. I won't belabor, I suppose, the statutory construction argument, because I think certainly the higher courts than the trial court have said that it's entirely a matter of the judge's discretion. So even if I could persuade the court that Mr. Vaughn is eligible, were the court to decline to impose a youthful offender alternative, that would certainly be within the court's discretion. And that seems to have been the pattern in the cases, two of which originated from Elkhart Circuit Court, where the young person was eligible, but the trial court declined to select the youthful offender alternative. All of this is to say, I suppose, Your Honor, that I think my best arguments for Luttrell can be made no matter what path the court decides to go. So, with the court's permission, I'd like to turn to the mitigating factors and leave the legal debate for the court to decide in its own time. Absolutely. Thank you, Your Honor. Everybody on this side of the bar has been through this before, and it never gets easier. I get older, and the people I defend seem to get younger, and the victims of their crimes seem to get younger. And frankly, listening to one grieving relative is one more than anybody would ever want to hear from. So I really find myself inadequately able to say anything to Dakota's family that would mend the wounds I know they're suffering from, other than to say I found Francisco Gallegos' comment so personally moving that I'm struggling to get through my presentation here because of how graceful he was. But I suppose what I would say first, and this is meant for the court, the trail, and for the family of Dakota, is that Luttrell has come to this court and accepted responsibility for the role he played and the circumstances that led to young Master Gallegos' passing.
For the role he played and the circumstances leading up to. Come on. If he's going to take accountability and responsibility for murder, then you should say that. Not for the role he played. Not for the circumstances around it. Come on.
Through his acceptance of a plea agreement. Now, I recognize that the mitigating weight that the court gives to the defendant's decision to plead guilty has to be weighed against the concessions that the defendant received in exchange. But I thought Mr. Gallegos said it well when, one gift, if you wish to see it that way, that Luttrell gave us by electing to plead guilty was we would not have to go through a second agonizing trial after having done it once before and having put in a week's worth of effort that was taxing on everyone, chief among them the family of the departed. So I would begin.
I could be wrong, but I think the mistrial was because of the families fighting. I think they went through a trial, it was mistrial, and then he pled. I could be wrong, but I think that is what happened. They went through a trial, and the families kept fighting in the gallery, and there was a mistrial.
By first
I'm going to look it up.
mentioning the mitigating factor of the acceptance of responsibility through the plea agreement, but also through the statement that Luttrell has given to the court. He's apologized to Dakota's family, to his family. And I spoke with Luttrell yesterday when he presented this letter to me, and the one thing he I suppose, thought was perhaps an important moral distinction was that this all happened in sort of the blink of an eye. I don't know if that necessarily makes anybody feel any better, but I want to acknowledge his acceptance of responsibility through both the plea, but also through his own statement that he's provided to the court, in which he expressed.
We don't care about his statement, sir. We really don't. Okay, it's worse than I thought. There was a trial, a jury trial, okay? The jury returned felony murder convictions. The convictions didn't stand. The judge, the court, set aside and declined to enter judgment on those felony murder counts. So it doesn't mean he's innocent, but the judge said no. Oh man, I wish we would have gotten that. That would have been unbelievable. So then he pled. So then he pled to robbery with a firearm enhancement. So this is not, this is sort of replacing a murder conviction, a robbery conviction. And I think the reason why is they robbed him, but he might not have pulled the trigger. Or they couldn't prove that he was actually the one that pulled the trigger. That's why the judge said no to the murder convictions.
Expresses his gratitude to the court as well as his deep sense of regret for the events that happened in that house almost exactly 1 year ago. Now, the second factor in mitigation is his age. On the 15th of January, 2025, Luttrell was 17, but he was much closer to 16. His birthday is in November. So at that time, he had been 17 for approximately 6 weeks. When I consider the evidence that was presented at the first trial, what the impression that I felt was that everything that happened inside the home in Mishawaka that night was so emblematic of youthful decision making. There was evidence of a decision at minimum to swap firearms. These were very young people engaging in very adult behavior. And as everything unfolded so fast and so suddenly, I think the choices that Luttrell made and other people in the room made just so reflect the impulsive and irrational and illogical thinking of young people. And so I don't view this just as his calendar age making him young, but having heard the evidence that everything about the events that night were the poor decisions of very young people. Now, I'm almost 43. Would I have made better decisions?
Poor decisions of young people? No. A poor decision of young people requires the fire department to get your head out of something. You know what I mean? Or you have bangs that are 3 inches too short. Those are poor decisions. You drink way too much Red Bull and vodka drinks. Those are poor decisions. A poor decision is not collaborating with another human being, robbing and murdering someone. That's not a poor decision. And I hate when they use those words. That's not a youthful decision. That's not because he was too young to understand.
Certainly like to think so. But I think that people smarter than I, social scientists, psychiatric professionals, education professionals, all agree that young people do not have fully formed decision-making functions, especially at that age of the borderline of 16 and 17. So I mentioned his youth and mitigation, not just because it is a demonstrable fact that he was a boy, but because so much of what happened reflected a boy's way of thinking. Now, in broad strokes, I would next turn to the mitigating factor of the character of the accused and his likelihood to respond to rehabilitation. And I suppose I would here begin by noting that it is the philosophy of this state expressed in our Constitution that the aims of the justice system should begin with rehabilitation in mind. Now, that takes many forms. The Department of Correction is certainly one tool that the justice system has to rehabilitate. That's for a different argument, I suppose. But in terms of this young man's amenability to rehabilitation, I would note this, that in the year that he has spent in custody, the vast majority of which he spent in the juvenile facility, he continued his schooling, and he's earned enough credits to graduate with his high school diploma. He is awaiting the results of the ability to take the SATs, which now that he's in an adult facility, it's been somewhat impractical for him to take the test. But in this year, despite the humbleness of the circumstances in which he has been incarcerated, he has continued his education, and he is just shy of earning a diploma. Beyond that, he's applied to Ivy Tech with hopes that wherever and whenever he can pursue advanced education. When we spoke about what he would like to do with that education, I was personally quite impressed with his vision for the future of wanting to work in logistics or management, which I thought were career paths I did not expect someone of his age to even know existed, let alone self-identify as his plan for his future. I think his character comes through in the numerous letters the court has received, which corroborate what I've learned in the year that I've had to know Latrell, which is that in many ways I view him as a typical teenager. He likes sports. He's somewhat soft-spoken and reserved in his personality. But in other ways, he's not a typical teenager, but in the best sense of things. He had a part-time job prior to his arrest working at Dairy. I think, knowing young people as I do, the part-time job that I've had in high school, I imagine many people in this room did, something that this generation of young people doesn't seem to prioritize. So I noted that with interest, that I thought set him apart from his peers. I try to come to what I
Exactly,
think is
JK.
objectively reasonable
Exactly. Hi, Cujo.
about what the court ought to do
I'll tell you what the
to
court ought to
sanction
do.
Luttrell for, to be blunt, crimes that he committed under circumstances that led to the loss of Dakota Gallegos' life. And we'll say it is true that he's not going to stand convicted of taking Master Gallegos' life. That is certainly an inescapable fact of the events that occurred on the 15th of January last year. I don't know if there's any amount or any sanction that the court could impose in this or any other case that would heal the wounds felt by the family of the departed. But my interest is in this young man and more so this young man's future. I think by the objective measurables we see revealed in his pre-sentence report, which are contextualized by the letters of people who know him best, I think we have every reason to believe that this young man will grow, will prosper, and more than that, will lead a life in the future that is altered by this, but that will make people in this room think differently of him and be proud of the adult that he grows into. We have talked, and I can say this on his behalf, he would like, if possible, in the future to be an example for other young people. That
Rub it into the family.
the decisions
Go ahead.
one makes, even in the blink of the eye, have devastating consequences for those who lose loved ones, those who lose loved ones, and those who have their loved ones sat in this seat awaiting a sentence.
Why can't it be
I
just as
genuinely-
easy to make a stupid mistake and give someone $7 million? Instead of a stupid mistake and they lose a life or a limb or an eye. You know what I mean? Oh, I made such a stupid mistake. Now you have $7 million.
I believe that about Luttrell, but I think it's not hard to get there when you look at the data the court has about it. My recommendation to the court is that it impose a 20-year executed sentence. I recognize that as the minimum under the plea agreement that Luttrell signed. If the court believes that additional time is needed or warranted under the circumstances,
Circumstances again.
The court suspend any time beyond the 20 years, which would allow the court some ability to monitor.
Yes, it is. The same judge. This is the same judge that had to keep pulling family members off of each other during the trial.
And perhaps provide other people in the room some measure of relief to know that if Luttrell is serious about
I have to go get my phone.
pivoting his life, then his next 2 decades will be time well spent and will return to us as someone that every mother would be proud of. But if he does not, there would be additional time withheld as perhaps a sanction for Luttrell's failure to follow through with what I know in his heart is his genuine desire to make a positive life. I think the 20-year executed sentence is appropriate. Beyond that, if the court believes additional time is necessary, I'll leave that to the court's discretion, but I do think it ought to be suspended. Now, with respect to whether that sentence is done as a youthful offender sentence, I think everything that the court could need to make that decision is before it. But ultimately, it falls to the court to make that decision. Whatever the court does, I want everybody to have an opportunity to watch this young man grow. And I think that he will, in his own way, try to mend the hurt that people feel by leading a life that will show, horrible though this was, he used it as a catalyst for change. Thank you.
Thank you, Ms. Masters. Oh, yes.
In regards to the issue regarding whether to sentence individuals as a juvenile offender, I, like Mr. Masters, did an extensive review of case law pertaining to the issue. Briefly, one of the cases with sentencing memorandum presented additional cases to the court, James and Harris. I reviewed Mr. Masters provided the decision for, I guess my interpretations of the sentencing are different. I looked at the transcript from the sentencing from first, essentially in the case, there wasn't an argument about time-wise sentencing there. In my interpretation of the facts was that Mr. Kimmel more so sought to use that as his age at the time of the offense, the commission of the shooting, which was 17, as a mitigating factor to try to shorten the sentence for him. There was not really any discussion regarding the actual verbiage of the statute and how it applies in this case. And when we looked at the court's decisions in James and Harris and Way, those were situations where the age of the offender were also not addressed, but merely whether that played as a mitigating factor. It didn't interpret the statute, mostly because those were younger offenders. They weren't in the same situation that we are here with Mr. Bond. So when we look at the statute, the court drew our attention to comparing kind of to the source of case law. I don't think that he would qualify for the alternative sentencing given his age for the reasons that the court had listed to the parties. I defer to the Department of Corrections as well, because they're the ones ultimately dealing with this on a daily basis and having to deal with the statute. It's a new area, but if the court would deem it appropriate that he would be sentencing that, and draw the court's attention to those decisions that the state had not only briefed in memorandum, but also in the decisions that were provided in James and Harris. Those individuals with similar situations as you see with Mr. Bond, that there were direct previous exposure to the juvenile system, prior criminal history, that looked at kind of the circumstances of the offenses. Some of them were committed in the presence of individuals under the age of 18, younger victims in that respect. And it is different because
So he did this in front of children. There were children present. Oh gosh.
he was
Oh gosh.
18 years right now. So this isn't a situation where we're looking to sentence him if he's 14, 15 years old. I think that's completely different. So I would object to, or I would ask the court to consider not sentencing him as a juvenile offender. Now, when I move towards aggravating and mitigating factors, the state listed many of them in their sentencing, and I'm not going to read over everything. But to highlight, there are some statutory aggravating factors that apply in this case, including the harm, injury, or loss suffered by the victim in the offense was significantly greater than the elements necessary to prove the commission of the offense. Mr. Long's injury of committing robbery resulted in serious bodily injury. I think it's clear from the testimony from the witnesses That Dakota, I guess, was just seriously injured during the commission of that offense, but in fact died. Her testimony from the pathologist that he had sustained a gunshot wound, and then there was a projectile ultimately recovered from the scene as well. The state note and argued that the defendant also receives significant benefits to the plea agreement that he has entered into today. Both parties have had long conversations, the state had long conversations with the family members, particularly videos. But also, the state considered the 4 juveniles that were present in the house, 3 of which testified in the impact and the effect that that had on them in reaching the state union as well. So I believe that the harm, injury, or loss suffered by the victim is an aggravating factor in this case. The defendant does have a history of criminal activity, as is outlined in the state sentencing memorandum. In 2023, he was charged with resisting law enforcement as a class A misdemeanor, including possession of a firearm. He was ultimately adjudicated in entering admissions on the possession of a firearm. In 2024, he then was later charged with resisting law enforcement, which he was involved with the level 6 resisting law enforcement as a class A misdemeanor. He was essentially adjudicated entering admission to misdemeanor. He was on probation for that offense at the time that the robbery occurred. And in connection to that offense, there's also modification reports that listed a number of violations. One being his presence at the house party on November 30th of 2024, where he was shot in the arm or in the shoulder by a firearm. Later on December 16th of 2024, the probation department indicated that he was enrolled in virtual learning, and he was unenrolled due to his lack of progress and participation in online courses. So there were, resources being available to Mr. Vaughn that he did not take advantage of, that he did not do. I recognize that while in custody, he was finishing school at the JJC, but then he was not in custody out and about. In order to do so as a term of sentence, he violated those terms of sentences. In that same JD case, there was a number of incident reports, including one that was filed while he was in custody on August 28th, 2025, where it was alleged that he had essentially struck an employee of the JJC during some sort of altercation. So I do believe that that demonstrates a history or a pattern of criminal behavior from Mr. Vaughn. The presence of a child in the commission of offense outside of the victim under the age of 18. There were a number of juveniles in the home at the time of the robbery, including the Logan son, who was 16 years old, Leah Reynolds, who was 14 years old, has been injured at 11 years old in Chase Van Diver, 13 years old. We know that 3 of them had witnessed the events that could have transpired because of her testimony from Logan, Aaliyah, and Chase at the time. And that's not including Mr. Vaughn's co-defendant, Mr. Gibson, who was 13 years old at the time of the commission of the offense. And that the person has recently violated conditions of the probation, parole, or human corrections, as the statement stated. He was on probation at the time of this offense in 71 J01 2409 JD 298, and had numerous violations, but also when this was done at the time he was on probation. As regards to non-statutory aggravating factors, it addressed the shared circumstances of the crime. This is briefly briefed in the sentencing memorandum that the state has provided. I don't agree with the position that this was a crime of impulse. And I say that because during the trial,
It's not impulse.
Of the actions that led up to this offense, and that it was Mr. Vaughn's cousin who drove him and Mr. Gibson to a house where he didn't know anybody inside, the children didn't know him, They testified that they didn't know who he was, they just knew Simon Gibson. But when they drove to the house, they didn't park out in front of the house or anywhere near, but made it a point to park in an alleyway with someone remaining in the truck. They exit out of the vehicle, they come to the house and look at everything. And it's not that things popped off at that point. They exit the
Okay, I see article in 16 News Now, WNDU, Mishawaka news station. The jury was deadlocked on the murder charge. So the other article that said the judge threw it out, this WNDU said that it was in South Bend, that the jury ended up deadlocked over the weekend on the murder charge. So that's why he wasn't charged with murder. The jury found him guilty on lesser charges. But the jury never made a decision of guilty or not guilty on the murder charge. So I think that's why they said the judge, I don't know, this article is way different than the other one, but it says here that it was deadlocked.
home, because that's what all the witnesses say, and Mr. Gibson said as well. And security footage shows them coming back, circling around the block, and coming back into the house, and going right to the back room, armed with guns, and with masks on their face or face coverings. So I don't necessarily agree with Mr. Masters on essentially the opinion that this was a crime of impulse. I believe this was premeditated. I believe that we took many steps to carry out this event. And I would note that Mr. Vaughn was the oldest out of the group of the individuals involved. He and Mr. Gallegos were both 17 years old. His co-defendant was 13, 14 years old, and the other children were even younger in age. And I think that that's relevant when it comes to that. I think the fact that it was committed in the presence of a number of minor children at that time, it's not just that, Mr. Gallegos' family was greatly affected by this, but you also have a group of children inside a house that saw this transpire, that saw someone that they believed to be like a brother to them, essentially killed in front of them. We saw the crime scene photos of their testimony from the officers. He died in the floor of their living room. And that's something that at 16, 14, and 13 years old, 11 years old, is something that they're going to have to live with for the rest of their lives, and it's have a standing effect on them as well. I think it's clear from all family members that this is a difficult case. So we're dealing with a group of young individuals, and it's hard. It's one of the more difficult cases that I've had to prosecute in my career. But it's clear that from the family members from Mr. Gallegos what impact that this leads to them through letters and what his sisters have to endure. His Francisco Gallegos and his granddaughters have to suffer for this. They never get to see him again. He just kind of remains in time as a 17-year-old boy, or doesn't get to graduate school, or anything along those lines. So we don't get to see him grow into potential that Mr. Masters says that Mr. Vaughn has, which I commend Mr. Vaughn and Mr. Masters. That is to happen, and that will be his future. But he robbed Mr. Gallegos of that opportunity for him to have those opportunities. He robbed his family of that. With everything, I would ask that the court sentence Mr. Vaughn as an adult, and I believe that given the circumstances and the statute, the aggravating factors in this case, that Mr. Vaughn received a sentence of 40 years executed. Thank you.
Thank you, Ms. Gallegos. Mr. Vaughn, is there anything that you would like to tell us?
You can talk now, or I can just remind the court. I did read your letter, so
You're under no obligation, but this is an opportunity for you to present what they call a statement of allocution. So if there's anything that you want to say here in court, you may.
And Your Honor, just when we spoke yesterday, Luttrell just didn't think he'd have the composure to speak in open court, which is why he penned the letter to the court.
And I read the letter.
Thank you.
The letter referenced about how the court had heard everybody else's version of what happened and not his. So I at least wanted to give them an opportunity to elaborate.
Your Honor, thank you for doing that. We spoke in great detail about his letter and what his meaning was. But his decision to not add to it today is the same one I left to it, or he left me with yesterday. He just didn't think it'd be possible for him to speak in court. So I can answer questions about his letter from my knowledge, or I can simply say that he's written to the court feeling that he would better express himself in writing than he could in open court.
Well, when he says there was never any intentions of a robbery or for anyone to be hurt, nor were there ever masks and gloves present at any time. And they didn't bring firearms to trade. Is your client accepting responsibility for the robbery to which he is pled guilty to?
Yes, Your Honor. His meaning there is that he wanted, suppose everyone concerned to know from his perspective, he did not go to that house planning for this to unfold. However, he agrees, and I specifically went through this with him, that notwithstanding his view that there was no premeditation, the crime itself and the intent to commit the crime can be formed rather quickly. So once inside the house, he agreed that through placing Dakota Gallegos in fear, he took the firearms from Dakota Gallegos' presence. That was something in his letter that I noted when he presented it to me. I anticipated the court may ask this question, so I asked very directly for an explanation. Mr. Vaughn's explanation to me was simply that he felt there was a moral distinction between planning ahead of time to do something awful versus doing something awful but impulsively and without premeditation. And I guess for the good of the cause, you agree with me. Thank you.
Okay. So, Mr. Vaughn, you are not denying that you committed the robbery that was pled guilty to. What your attorneys explained to me is you want me to know you didn't premeditate this. Okay. So it was noted in at least one of the pretrial filings, this case is a little unusual in that it's a guilty plea, but the court is aware of all of the facts of the case, having presided over the jury trial, which ultimately.
Hear that? Hear that? The judge says, I was the judge during this trial. I'm aware of all the facts in this case. So yeah, we're pleading to a robbery, but I saw what happened in the videos.
This trial. Mr. Masters noted that as defense counsel, he's getting older and his clients are getting younger and the victims. And the court would reiterate that from its perspective. I don't suppose there's any easy sentencing hearing for the court because the court is well aware that whatever the decision is it will impact someone's life forever. And in these cases, it impacts not only your life, Mr. Vaughn, but virtually everybody sitting in this room. And I imagine several other individuals who may not be here in person, but watching, friends and family. It's the pebble in being dropped in the pond and the ripple effect just doesn't. There's a lot to sort through here. I want to address first the issue of whether or not you can be sentenced as a youthful offender under 3134-2. And the case law on that is relatively new. I did read the cases submitted by the state, James and Harris. I also read Bird. And I'll note I have actually some tangential familiarity with a couple of those cases. Alphonse and James in Elkhart County, the very first line in the opinion in that case is that Alphonse James, his father, was killed during a drug deal on law. And I know that intimately because I prosecuted the two individuals who killed Alphonse James with then Chief Deputy Prosecutor Jerry Dickey Jeffrey, elected prosecutor. So I am aware of that. And serving as a prosecutor, serving as a defense attorney, I know that what happens when there's a murder and when there's a sentencing, the effects are long-lasting, especially to defendants. Mr. Bird's case, for whatever reason, I did obviously not preside over that case, but for whatever reason, when I started off on the bench, I was faced with the issue of sentencing for Mr. Bird's co-defendant, Mr. Rios. And although the court did use its discretion and impose youthful sentencing alternatives for reasons that I will explain may be distinguishable from this particular case. Bottom line is ultimately whether or not you are eligible by statute. This court will assume, Mr. Vaughn, that you are. To the extent there's any ambiguity in the statutory language, the court leans upon the doctrine of lenity, which means that ambiguity must be interpreted in favor of the defendant. Now, that statute provides that if there is a conviction for an individual who is, I guess in this case, we'll say 18, the idea is that the court would impose a sentence which could be executed to the Department of Correction, but would suspend that sentence, place that individual in the juvenile division of the Department of Correction, and prior to that individual's 19th birthday, the court would hold a hearing to consider a modification. In this case, Mr. Vaughn, if the court were to go that route, we would be gathering here again in no less than 10 months from now. Ultimately, it's the court's discretion and the authority provided by the parties. I think the case of first impression of leg is they look to the juvenile waiver statute to provide the court with at least some guidance. Is the act heinous or aggravated with greater weight given to acts against the person or than acts against the property, or is there a pattern of repetitive, is it part of a repetitive pattern of delinquent acts? Is the child beyond rehabilitation under the juvenile justice system? Is it in the best interest of the safety and welfare of the community that the child be treated as an adult? Well, first of all, there can be no question that the offense here is heinous and aggravated. It is a crime against the person, de Gallegos. And for reasons I'll explain in more depth, the court also finds it does appear to be a pattern, part of a repetitive pattern of delinquent acts given to prior adjudications. child beyond rehabilitation under the juvenile justice system. And that's always difficult for the court to say, because the juvenile justice system, hope springs eternal. The idea is that there are a variety of resources and measures that can be taken. You have 2 prior adjudications, and while the court will concede that's not the most it has ever seen, when I look in depth, it does seem as though you had given a step up in supervision, but ultimately here we are now, Mr. Vaughn, you barely turning 17 now in adult court. Under some of the most serious circumstances that appear in this court. So when I considered whether or not you are beyond rehabilitation by the juvenile justice system, there was a juvenile adjudication in 2023 for dangerous possession of a firearm. You were placed on strict and indefinite probation, which reported that you successfully completed that probation on November 14th, 2023. About 10 months later, there was another delinquent act that's resisting law enforcement. You fled from the police. You were caught with ammunition in your pocket. You were placed on home detention for 45 days, followed by a term of probation, gravity day reporting as well. And then there were the alleged violations that you were at a house party. In fact, you were shot at a house party. You were not enrolled in school, and of course, there's this offense. So when I consider the underlying facts and circumstances of your juvenile experience, there are 2 consistent themes to the court. One would be an opposition to authority, and 2 would be a dangerous fascination with firearms. You know the dangers of firearms, Mr. Vaughn. You were shot. You had the juvenile adjudication for firearms. Those experiences did not seem to stop you from gravitating towards firearms. And in fact, in this case, the very basis was this firearm transaction.
So he had a prior record, and he was shot in the past with a gun. Well, that's what shot means, but
Something like 8 or 9 firearms. And during the trial, the court keeps custody of these, and it seemed as though every time I had to walk into the courtroom after a recess, the stack of firearms I had to carry into the courtroom grew and grew. So when I consider whether or not you're beyond the rehabilitation of the juvenile justice system, based on those facts, the court does believe that you are beyond rehabilitation of the juvenile justice system. And given the nature of the offense, again, involving multiple firearms, involving the shooting of Dakota Gallegos at a location in proximity to a school, in the presence of 4 minor children, the court does believe that the best interest in safety and welfare of the community is that you are treated as an adult. So the court does find, Mr. Vaughn, that while you are eligible for treatment as a youthful offender, the court in its analysis exercises discretion to not use the youthful offender statute and to sentence you as an adult. Now, let's look at the aggravating and mitigating factors. The mitigating factors are those that are good for you, Mr. Vaughn, and the aggravating factors are those that are not good for you. The state says there are no mitigators. The court disagrees. First of all, you did accept responsibility by pleading guilty. The state argues that that should be given minimal weight, or I think his argument should be given no weight because there is a significant penalty.
yeah, because it was after the trial.
The court does not agree that it should be given no weight, but it does agree it should be given minimal weight. I would otherwise agree, but Mr. Francisco Gallegos came up here and in a manner that the court agrees with Mr. Masters is not typical, coming from a victim representative, expressed forgiveness, expressed some semblance of obviously regret, but also hope for you, did express to the court his appreciation that this did not go through another trial. So the court does give some weight to that. The court did note going into this that it appeared that you were minimizing what you actually did in your letter. I think that has been cleared up. Mr. Masters argued that this happened in the blink of an eye. The state argues that it's not really a crime of impulse. And here's how the court sees it. I would certainly agree, Mr. Vaughn, that I don't believe that you went into that home intending to kill Dakota Gallegos. I do believe that you intended to rob Mr. Gallegos. And that's based on the evidence I saw. I believe there were text messages, and though while not admissible to the jury, the court can consider that because it can consider the evidence. There was the surveillance videos all around. There was the testimony from the individuals inside. You went in the first time with Gibson. Then there was the explanation that you leaving, you may or may not be back. But several of the juveniles inside the house testified that you came back with guns and masks. You dispute the mask portion, Mr. Vaughn, I understand that. But based on the overall totality of the evidence, the court does believe that you did intend to rob Mr. Gallegos, that decision was not made at that moment in time. And you, having been aware of what a firearm can do, having been shot yourself, should have been well aware that there was always the possibility that someone was going to get hurt. Someone got more than hurt. Mr. Gallegos was killed. You shot Dakota Gallegos. You do have strong family support, and the court does consider that in mitigation, Mr. Vaughn. I read all of the letters. So the court acknowledges and sees a gallery full of individuals, recognizing some are here on behalf of Mr. Gallegos, but some are also here on behalf of you. And that was the case during the trial. Mr. Masters argues I should consider as a mitigating factor your character and your likelihood to respond to rehabilitation. And that the philosophy, the constitutional mandate is that the principles of the criminal justice system should be founded in rehabilitation and not retribution. Now, Mr. Rice came and testified on your behalf, and I found that to be a very enlightening presentation. I don't often hear the aftermath when individuals have served time in prison. Usually after they are done, the last place they want to be is in court. But Mr. Rice, I think, has a lot of good information that would provide a lot of positive, would provide a lot of guidance to, I think, young individuals in our community. And it sounds like he is in fact doing that. This is someone that has known you, Mr. Vaughn, for 14 years. This is someone that no doubt has been candid with you and has shared his experiences and likely pulled you aside when you started getting involved in the juvenile justice system to say, hey, you need to cut this out. This is going nowhere fast. But you did not avail yourself of Mr. Rice's mentorship or any of the other 20 plus people who have all stepped up in your corner. You have continued your schooling, Mr. Vaughn, and the court does consider that in mitigation. You were working at everything. I understand what Mr. Masters is saying. I think nowadays you don't see a lot of kids actually getting any type of job, frankly. So I would consider that in mitigation. You are young. You just turned 17 at the time of the offense. The court considers that, but it does note that you nevertheless continue to get involved in the juvenile justice system. When I turn to the aggravating factors, the court agrees that the nature and circumstances of the case are aggravating. Pled guilty to robbery resulting in serious bodily injury, and the court understands why the parties reached that agreement. But Mr. Gallegos is dead. He was killed. I heard from the forensic pathologist, and the cause of death was a gunshot wound. So Mr. Gallegos' death exceeds the necessary elements to prove the elements of the flood offense. This crime was committed in the presence of children. The ages I have written down may slightly differ from what Ms. Galvieski told me. I think I got the ages from JB, who testified first. I believe he said he was 13 years old. AR, 14 years old. LW, 7.
Oh my God, the kids testified at the trial. What the heck? I'm just going to bump it back a second because I paused it at a bad spot.
Testified first. I believe he said he was 13 years old. AR, 14 years old. LW, 17 years old. And then there's KR, who is in the bedroom. He is 10. This court does not often get individuals at that age testifying in any case, let alone a murder case. Your co-defendant in this case was 13 years of age. So that is an aggravator that the court places a great deal of weight on, because any one of those individuals could have been injured by the events that transpired in that house. Whether or not they were physically injured, safe bet that all of those individuals have some psychological injury based on what they were forced to witness or be a part of on that day. I consider your juvenile adjudications as aggravating factors, noting that there is an escalation of offenses. There's the possessing a firearm, there's resisting law enforcement, there's this case. And again, alternative forms of rehabilitation have not proven successful, Mr. Vaughn, in getting you to conform your conduct with the law. You've been placed on strict and indefinite probation, home detention, day reporting, parental intervention, none of which have proven successful in getting you to conform your conduct with the law. You were on juvenile probation at the time of this offense. Court also considers that in aggravation. I will note, I do consider your statement, all statements of Mr. Masters as well, in mitigation. That wasn't clear. When I weigh the aggravating and mitigating circumstances of this case, Mr. Vaughn, I do find that the aggravating circumstances outweigh the mitigating circumstances. warranting the imposition of a sentence at or near the maximum provided by the plea. The plea does call for a floor of 20 years and a cap of 40 years on executed time. So, Mr. Vaughn, when I weigh the aggravating and mitigating factors for a level 2 felony, the sentencing range is between 10 and 30 years. The advisory is 17 and a half years. In weighing the aggravating and mitigating factors and finding the aggravators outweigh the mitigators, the court enhances the 17 and a half years to 25 years, but it does suspend 5 of those years on 5 years of withholding probation. The court does suspend those 5 years in acknowledgement of the mitigating factors that have been proffered by your attorney. As to the firearm enhancement, the court can add anywhere between 5 and 15 years. And the court finds, again, the aggravating circumstances outweigh the mitigating circumstances. The motivation of this offense was to procure more firearms, despite the fact that you had already been, I would suggest, warned both of the juvenile justice system and your own personal experience of being shot to avoid firearms. And for this reason, the court believes that the full 15-year enhancement is appropriate. That is consecutive, it is non-suspendable. This deals Mr. Vaughn a total sentence in this case of 40 years, 5 of which, as I said, are suspended on 5 years of reporting probation. The court does award you 365 days of Class B credit against that sentence. I do want to revisit one issue with you, Mr. Vaughn, right now before I go into the terms of probation. The court has declined to impose the youthful sentencing alternative for the reasons I said before, but also because it does not believe that the court would change its mind in the next 10 months. I'm sure Mr. Masters has made you aware, and in fact, had probably planned for this in the plea, but because you committed this offense and you were less than 18 years of age, Indiana Code 3538-117 N 1 does allow you to petition for a modification of sentence without the prosecuting attorney's consent after you have served at least 15 years of your sentence. I'm telling you that now because I don't know what the status of the modification statute is going to look like after that time.
That means he has to serve at least 29 years before he can petition for that, because he gets 1 year credit. So he has to serve at least 29 years before he petitions again for the youthful offender bonus.
But it's worth preserving for the record that at the time you are convicted and the court is pronouncing sentence, the modification statute does allow you, under these circumstances, to petition for a modification of sentence after you've done 15 years of your sentence. I'm going to put a big caveat that first, I don't know if I'm going to be the judge if and when that time comes and you decide to go that route. If I am, I make no promises or guarantees. As I sit here today, the court believes that the sentence it has imposed is entirely appropriate. But I wanted to at least give you an opportunity to move on, since you are very young, to know that there is hope, and to listen to what Mr. Rice has told you here in court today. All right, let's talk about the probationary terms. While you're on probation, you'll complete an IRS assessment, and based on those results, participate in a treatment program, educational class, or rehabilitative service provided by probation, which referred to an outside agency. You're not using controlled substances without a valid prescription, or using any illegal substances, nor can you consume alcohol. Submit to random drug and alcohol testing and pay for the same. Report to probation at the times and matters as instructed by them. Work faithfully and diligently to seek and or maintain employment and or pursue educational opportunities. Remain in the county with given permission to leave it. Notify probation of any change in address within 3 working days. Consent to probation visiting your home, place of employment, or elsewhere. Waive any and all rights to search and seize and agree to submit to search for personal property while you're on probation. Waive extradition, agree to return or be returned to the county without an extradition hearing. Violation of any law will be considered a violation of probation. Do you understand the terms of the probationary period, Mr. Waller? Right, you may not purchase, use, possess, or exert control over a firearm or any other dangerous device. Is there, I don't believe there's a no contact order in terms of the plea, but are any of the victims' family requesting that, Ms. Albiewski?
No, Judge, we haven't discussed that.
I doubt that Mr. Vaughn is going to be reaching out to them.
Right, I would ask that there would be no contact order just issued for just safety purposes in case. I don't think it's going to be issued. I don't think we sign contact them, I guess, over and when it's a call.
I suppose I would need you to send it to
Sure.
the court, who specifically you would want.
I'll speak to the family about it, and if I do feel that the court or the family would like it, I'll file a motion and include.
We may very well have to have a hearing on that.
Okay,
So,
I don't have an answer to that right now, though, so. I would say just as a caution, then yes, and then I'll
all
provide the
right,
names.
well, Mr. Vaughn, I'm going to prohibit you from having any contact with any victims of the family. Now, if you are contacting someone you are unaware of is in fact a family member of Mr. Gaggins, that's not a violation. But to the extent you know who these family members are, you're prohibited from reaching out and trying to contact them direct or indirect. You understand that, so. All right, do you have any questions about the terms of the probationary period, Mr. Vaughn? I'm gonna have you sign that. Now, Ms. Galvieski, I don't know that restitution is part of the plea, nor has there been any documents submitted in support of that. I would suggest Mr. Vaughn's age and his incarceration in the last year and future incarceration is going to render him indigent.
Yeah, the state sent that requesting restitution.
Okay. Ms. Galvieski, there are remaining counts, ma'am,
Yes, Judge, at this time, the state moves to dismiss or remaining counts.
so ordered. Ms. Galvieski, have I missed anything?
I don't know if the court wants to advise him of his rights to approve the sentence.
Well, there's a plea. you
Oh, that's
raised that,
right,
is it
you're
not?
right. No, then there's nothing else.
So the plea does waive the right to appeal the sentence, Mr. Masters, and I do not believe I have either violated the plea or sentence, Mr. Vaughn, legally. However, if there is a legal plea, you're always available to appeal that, I suppose.
I wasn't in this moment going to suggest the court that, to the court. And I say that as somebody who has an active petition to transfer to the Supreme Court in a case where I thought my client retained the right to appeal, but the court appealed to the Supreme. So it's of no moment at this moment.
Mr. Masters, are you private counsel in this case?
No, this was a court appointment.
All right, Mr. Masters, I'm going to show Mr. Vaughn as indigent for purposes of court costs as well as cost of defense. It is, of course, not a comment on the court notice towards excellent evidence.
No one is ever going to get money from him.
I guess as said, Mr. Vaughn, that possibly could have been 45 to 65 for murder plus the additional time on top of that. So I'll show your appearance withdrawn. Anything else, Mr. Masters?
No, thank you.
Mr. Reed, have I missed anything? Mr. Vaughn, you'll be remanded to the custody of the sheriff to carry out the sentence. Good luck to you.
Now we have to make sure that the families don't fight each other on the way out. The one guy in the middle who's standing now, he keeps standing up. I know he's making all the bailiffs nervous.
Gallery, what I like to do, Ms. Galviesti, you want to exit the courtroom and the friends and family of Mr. Gallegos can follow you.
Yes.
You are with Mr. Vaughn, I'd ask you to remain in the courtroom briefly.
He's protecting the prosecutor. That's so nice. I've not seen that before. That's so nice.
Please exit with haste, if I can ask you, ladies and gentlemen.
She always ends his stream. She always comes up and ends the screen. Every time I see her at the camera, I know, oh well, Francisco's done. Francisco's done for the day. No more Francisco. I really wish he would get a better microphone system. I wish every single court would get a better microphone system. It feels like those advocates that fight for, transparency in the courtroom. They should get their lawyers in these courtrooms and fight for a better microphone for us. But no, that judge didn't care one bit about youthful offender because he saw the trial. He heard the victims, the little kids, discuss what happened. There was no way that guy was getting youthful offender. None. Zip. Zero chance. And no, they couldn't prove who actually pulled the trigger. But I don't know if I don't know if they couldn't prove it or we just saw the prosecutor in action. We just saw her at a sentencing where she already won. So, I mean, I don't know how she was during the trial. But I don't know. No, he didn't. Yes, the taxpayers pay for all of that, but that's fine. I mean, what other option would we have for this little kid other than the taxpayers paying for it? I can't think of a better option than putting him, right where he is for the next 40 years. -5, -1. But then he was on probation when he did this. He was on daily probation, daily reporting probation. He had to report to his PO every day. And he still did this. Jeez. All right. As long as we didn't hurt Josh's ribs tonight, we're good. Josh, are your ribs okay? Don't sneeze. Do not put pepper on anything. Trust me, I fill pepper shakers at work and I'm a wreck sneezing for the rest of the night. All right. We have a live stream in a couple hours and I don't have anything ready. Nothing. So I got to get to work. Thank you so much for coming out tonight, guys. I really appreciate it. I really do. I hope that you guys have a great day. Hi, Brown. Yeah, true. See you in a couple hours. Or don't come in a couple hours if you were here and you need some freaking sleep. Sleep is very important, guys. Thanks, Smurf. Good to see you, too. Good night, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.